Hello friends, in the series on the income tax cases, today we will discuss an issue that if an assessee claims a exemption or deduction in his return of income and during the assessment proceedings, the assessing officer finds that that exemption or deduction is not allowable to the assessee, and the assessee himself comes forwards and furnishes all the particulars about that exemption or deduction, and it is also clear from the facts that the eligibility criteria of that exemption or deduction is not fulfilled, not on the part of not on the mistake of the part of the assessee, but mistake on the some third party, that is builder. So whether in that case, just because the assessee has claimed a wrong claim, the penalty under section 271 subsection 1 clause C can be levied on the assessee for furnishing inaccurate particulars. This issue has been decided by Delhi ITIT G bench in the case of Deputy Commissioner of Income Tax versus Sahil Vachani. This case is reported in 126 ITR Tribunal at page number 172, and the date of the judgment is 23rd June 2025. In the present case, the assessee has filed the return of income, and during the financial year relevant to the assessment year 16-17, the assessee has claimed an exemption under section 54F, and during the assessment proceedings, the assessee himself came forward and said that the property cannot be constructed in the due time which is there in section 54F, and hence the assessee himself surrenders the exemption and paid all the taxes and interest on that. The assessee also submitted the agreement with the builder, the bank statements, the TDS certificate, and the assessee explained that the registration of the property was delayed just because of the fault of the builder, and the assessing officer didn't find any mistake or any wrongdoing by the assessee in the explanation furnished by the assessee. But the assessing officer levied the penalty on the assessee and under section 271 subsection 1 clause C only on the allegation that the construction of the property was not completed on time. The assessee pleaded that the facts of the case of the assessee are bona fide. The assessee was under a genuine belief that the construction of the property will be done within due time, but it was beyond the scope of the assessee. It was not in the control of the assessee to get the property registered on time, but the AO didn't admitted the submissions of the assessee and levied the penalty. When the matter was before the CIT appeal, the CIT appeal was of the view that the penalty was on the premise that the assessee was unable to construct the property within the statutory limit, but that statutory limit was not fulfilled by the assessee, just not because of the fault of the assessee, it was due to the fault of the builder. The tribunal was of the view that the assessee explanation was nowhere held to be false or without any basis, and the tribunal said that it is not a case for penalty to be levied for furnishing inaccurate particulars. The tribunal said that if any information is gathered from the Google, then it was the duty of the assessing officer to get that information confronted with the assessee, and any information from the Google cannot be relied upon without confronting it with the assessee. The tribunal said that the tribunal do not have any right to travel beyond the facts recorded by the lower authorities, especially when the facts are gathered from the other sources. The tribunal was also of the view that in the present case, the assessee's explanation was supported by the documentary evidences, and the tribunal was also of the view that the cross-examination should be there when the AO relied on any facts which are gathered from third party. So in the present case, this decision was given by 3-member bench because there was division of opinion between the 2 members. So this matter was referred to the 3rd member, and the tribunal came with a view that simply because claiming a wrong claim does not does not come in the definition of furnishing inaccurate particulars. It depends upon a number of facts, and in the present case, the facts clearly depict that the assessee has not furnished any inaccurate particulars, and hence it is not a fit case for levying the penalty under section 271 subsection 1 clause C for furnishing inaccurate particulars. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax versus Sahil Vachani, and this case is reported in 126 ITR Tribunal at page number 172, and the date of the judgment is 23rd June 2025. Thank you, friends.